I've got discussion D for you. We're discussing when somebody is forced into assisted living. Okay, that is tonight's discussion D. Here we go. Sit back and enjoy, please. Okay, the story describes a relative who once trusted an attorney with both financial and health care power of attorney, only to discover years later that this attorney has quietly taken full control, arranging an assisted living move, hiring a visiting nurse, setting up auto payments, and even being added to the elder's bank account. The family member who wrote in is shocked to learn that 2 doctors have declared the elder mentally incompetent and fears that this means the elder has lost all rights. The article makes one thing absolutely clear: doctors cannot remove a person's legal rights. Only a court can. A durable power of attorney can continue even after cognitive decline, which can leave families feeling locked out and powerless. Key legal points the article highlights: doctor statements are evidence, not a verdict. Medical declarations of incompetency can influence decisions, but they do not automatically revoke rights or hand total authority to a POA. Only a judge can determine legal incompetency or appoint a conservator or guardian. Durable power of attorney. Durable POA remains active after incapacity. If the original document was drafted as durable, the agent's authority continues even when the principal's cognition declines. This is why banks refused to give the family member access. The attorney still legally controls the accounts. Conservatorship and guardianship is the mechanism for oversight. Anyone with a legitimate concern, family, friends, public officials, or other attorney, can petition the court. The court then appoints an investigator to interview the elder and evaluate whether they truly lack capacity and what level of oversight is needed. fiduciary duties and red flags. A POA must act solely in the elder's best interest. The article flags concerning behaviors isolating the elder from family, setting up auto payments without transparency, sudden changes in living arrangements, and especially adding the agent as a joint owner of bank accounts, something a fiduciary should not do. Practical steps the article recommends you take now. Request transparency in writing. Ask the POA, ask for the POA documents, billing records, and the doctor's statements. A POA is obligated to provide an accounting of how they are managing the elder's money and care. Consult an independent elder law attorney, not the attorney currently holding POA. A separate lawyer can evaluate whether the elder still has enough capacity to revoke the POA or challenge the agent's decisions. Capacity is not all or nothing. Someone may be impaired in some areas, but still able to make key choices. Okay, consider filing for conservatorship or guardianship. If the court finds the elder cannot manage finances or health care, it can appoint someone else, sometimes temporarily, sometimes in a limited capacity. This can pause or reverse questionable decisions, including unwanted placement in assisted living. Document everything: dates, conversations, who visited, what was said, bank irregularities, and any signs of pressure or isolation. This documentation becomes crucial if you need to challenge the POA's actions. Trade-offs and what to expect. Speed versus thoughtfulness. Speed versus thoughtlessness or thoughtness. Emergency petitions can move quickly but require strong evidence of immediate harm. Standard conservatorship cases can take longer because they involve interviews, reports, and hearings. Balancing safety with autonomy. Courts understand that cognitive decline is natural. A person may be unable to manage finances, yet still able to choose where they live or whom they trust, encouraging the elder to voice their wishes, especially in front of an independent attorney, can influence the court's view. Emotional and financial cost. Challenging a POA can strain family relationships and require legal fees, but leaving the situation unchallenged may ex, may be expo, may expose the elder to financial exploitation or unwanted placement. Quick checklist you can use immediately. Obtain copies of the POA, bank statements, and doctor's letters. Contact an elder law attorney for capacity review and legal options. Document all interactions with the POA, nurse, bank, and moving company. Ask the bank in writing whether the POA is a joint owner or merely an authorized signer. A critical distinction for fiduciary integrity. Okay, guys, now the second part is answers you can ask. Core answer. A mentally competent adult cannot be forced into assisted living. The only circumstance in which someone can be placed involuntary is when a court formally determines they are incapacitated and appoints a guardian or conservator with the authority to decide where they live. Okay. This is a high legal threshold designed to protect adult autonomy, and it cannot be triggered by family disagreement, a doctor's recommendation, or a power of attorney alone. Why this matters? Legal essentials. Competency is controlling factor. As long as a person understands their situation and can make reasoned choices, even even imperfect ones, they retain the right to refuse assisted living. Age, ability, or risky preference do not erase that right. Guardianship is the only legal pathway to override refusal. A court must see substantial evidence that the person cannot make safe decisions and is at risk of harm. Without this ruling, no one family, doctor, or agency can compel a move. Medical options inform but do not decide. A physician can recommend assisted living or document cognitive decline, but only a judge can remove decision-making rights. Doctors do not have the authority to force placement. Power of attorney has limits. A POA allows someone to act with the senior's consent or on their behalf when they cannot manage tasks, but does not allow overriding the wishes of a competent adult. How the guardianship process typically works. Guardianship is intentionally difficult because it strips a person of fundamental rights. The article outlines a multiple-step process. Okay, guys, give me 1 second. Okay, petition filed with the court. The petitioner must explain why the senior is believed to be incapacitated and unsafe. Medical evaluation. Courts usually require a formal assessment by a psychiatrist, neurologist, or geriatric specialist to evaluate capacity. Court-appointed advocates. A guardian ad litem or attorney is assigned to represent the seniors interests and ensure their voice is heard. Hearing and judicial decision. The judge reviews evidence, hears testimony, and decides whether guardianship is necessary, and if so, how broad or how limited the guardian's powers should be. And least restrictive mandate. Even if guardianship is granted, the court must choose the option that limits the senior's rights as little as possible. Involuntary assisted living is not automatic. Practical alternatives courts prefer. Before involuntary placement, the surrounding page emphasizes that guardianship should be a last resort, and that many situations can be stabilized without removing rights. Open, empathetic conversations that focus on safety, not control. In home care or supportive services, such as home health aides, medication reminders, meal support, or fall prevention interventions. Area agencies on aging, assessments, counseling, and care planning resources. Trial or respite stays in assisted living, or the senior can experience the environment without committing to permanent move. Courts expect families to try these options before seeking guardianship. Trade-offs and what to expect emotionally and legally. Autonomy versus protection. Guardianship can prevent harm, but also removes rights. Sometimes permanently, families often struggle with the emotional weight of taking this step. Time, cost, and conflict. Guardianship causes can take months, involve attorneys, and create deep family rifts. No guarantee or placement. Even if guardianship is granted, the courts may authorize only limited powers or require less restrictive alternatives before approving assisted living. Impact on relationships. Involuntary placement can strain trust between the senior and family members, sometimes irreparably. Immediate steps you can take now. The article suggests several concrete actions for anyone navigating this dilemma. Talk calmly and respectfully with your relative about their fears, preferences, and what safety means to them. Document specific safety concerns such as falls, wandering, medication errors, or inability to manage daily tasks. Courts rely on concrete evidence, not general worry. Contact your local area agency on aging for a home safety assessment, care coordination, help, and community resources. Consult an elder law attorney to review existing POA documents. Explain your options and help determine whether guardianship is appropriate or premature. These steps help you build clarity and avoid escalating to legal action unless absolutely necessary. Okay, guys. So that is your D for tonight. I will see everybody tomorrow for shows. For now, Gator Wellness. Take care, folks. I will see everybody tomorrow for shows. Have a good night, folks.